Hi, I'm Greg Dell with Dell Disability Lawyers here with attorney Rachel Alters, and today we're going to talk about one of Rachel's resolved cases, which is something that we love to do because it was a successful appeal on behalf of one of your clients against Reliance Standard. And then also in these videos, what's great about them is that people have the opportunity to not only learn what to expect in a denial or an appeal, but also some tips they can take away from this video that will help them to possibly avoid a denial in the future. So let's get into the background of your claim against Reliance Standard.
Sure. So this is a gentleman who was in his late 50s. He had a physical job working in a factory, and in 2004 he had a severe, really bad ATV accident where he broke his knee, a leg, an arm. He fractured his back.
Full body injury.
He had a lot of issues. So clearly he was out of work, and Reliance approved his disability benefits back in 2004 for the 2 years ONOC. Then he was also approved for the any gainful occupation period. 14 years later, they decided they're going to do vocational review, and the vocational review, the vocational expert opined that he was fine. He could go back to work now, sit at a desk 40 hours a week. He could, lift at least 10 pounds and absolutely no problem could work full time. So they deny his claim. Well, he's in shock.
Well,
because,
I want to back you up a second,
absolutely.
because you said it's 14 years later they do a vocational review.
Right.
What does that mean? Did they examine him?
No, they didn't. Well, actually, back up a little bit. They did send him for an IME in 2008. So during the claim review, they sent him for an IME, and what happened was their IME expert said that he could not work, that in fact, he would actually get worse over the years and not get better, and that was their own doctor that they hired. So this is in the administrative record, and then and currently they have a vocational review done.
Yeah,
which
this is 12 years plus later.
Exactly, yeah. But so this guy's not supposed to get better. They hire an expert who just reviews the records. He doesn't meet the client. He didn't speak to the doctors. Nothing. All he did was review the records and say, based on the records that I'm looking at, it seems like this guy can go back to work. Well, what actually happened is over the years, over 14 years, he started seeing the doctors less and less. There was nothing they could do for him. He walked with a cane. All of his injuries were not operable. So basically he was the way he was gonna be, and he was getting worse because he was developing arthritis, and as you get older, those injuries affect you more.
Do you remember how old he was when they denied him?
Well, he's in his mid-50s. Oh, okay. In his mid-50s.
Mid-50s?
Yeah.
Okay.
Yeah.
So it's crazy because we filmed some other videos recently, and one was a 22-year on claim denied, and the other one's 16, and now today you're saying 14. So, and I'm always shocked by that because the vocational review, was there something in the medical records of the claimant that said he got better? Was there video surveillance showing that he could do something? Did he post on Instagram or Facebook of him doing something great? What was it beyond just a hired gun being paid $1,000 to review his records? Was there anything?
No, there was nothing that stood out. I think what happened is they took the opportunity to catch him at the point where he wasn't going to the doctor very often, because these insurance carriers look that you're going to the doctor every 3, 4, 5 months to make sure that you're getting treatment, and that the doctors are writing your restrictions and limitations. Well, the doctors really had nothing to do for him, so he would go to a doctor maybe once a year or once every 6 months because his condition was permanent. So their big thing was, well, you didn't see a doctor, and when you did go to the doctor, they didn't write anything about what your restrictions and limitations were. They weren't documenting anything out of the ordinary. So if you just look at the records alone from the last year, you'd think maybe he's okay. But
right. And here, I'm glad you just said that word okay, because we say this a lot at the risk of sounding repetitive. Okay for someone who is chronically ill,
right,
with a chronic medical condition, is okay to that person. But okay when a person goes to their doctor for a checkup who has no medical issues whatsoever, right. The normal person's okay if they had the symptoms of this other person would be like a disaster. But the person who has chronic medical conditions and goes in and says they're okay,
right.
It's okay in the sense that, yeah, I can function on a normal day. I can walk, I can talk, I can feed myself, I can sit for an hour. But if you ask me to work 40 hours a week, 5 days a week, and commit to someone for 50 weeks a year, assuming they're going to get a vacation, there's no freaking way I could do that. So when I'm going to come in here and tell you I'm okay, I'm alive. I'm functioning. I have a good day, a bad day. I can go to the movies with my friends. I can go to dinner and do whatever. Yeah, I'm okay. I'm not dying. But the disability insurance companies manipulate that. And so you got involved in the case, in this situation, and what did you do in order to prove that he's still disabled?
Well, one of the egregious issues that we saw in the denial was this all happened during the initial COVID outbreak. So my client, because he had poor health, was in fear of going out to the doctors, and the doctors really weren't seeing people in the beginning. They didn't have the virtual visits. And the adjuster was very, according to him, unfriendly and insistent that he go get an attending physician statement signed by a couple different doctors. And
in person?
In person, because that's what they told him to do. And he didn't want to leave the house, couldn't really get the appointments with the doctor. Then he himself got COVID. And he was down for 3 weeks. And they were saying, if you don't get it in by this time, we're going to deny your claim based on the fact that you haven't gotten it. So he eventually did get something, but I guess it wasn't very supportive, so they used that against him. He was very upset. So when we did the appeal, what we did was we made sure he went to see his doctor, a couple times, and the doctors were very specific.
Right, because now you're a year after the initial COVID outbreak.
Right, so we had the doctors make sure that they wrote specific, documentation on what he can do and couldn't do and why. And, when they did the physical examinations, they documented that, specifically what was wrong with his knees. He actually is in so much pain at night, he can't sleep in his bed. He sleeps in a recliner because he can't lay down fully. And they want this man to work 40 hours a week. So we made sure the doctors were supportive, the records were supportive. We had another attending physician statement prepared by his physician that was very detailed and basically pointed out to them that they had no proof that he ever improved. In fact, he's gotten worse, and we had proof that he had gotten worse over time. So they reversed the decision, realizing that obviously it was improper, but had we not been involved, he probably would not be back on claim.
And in terms of working with the doctors, did you communicate with his treating doctors? Because I always tell people when we do these appeals that like 25% of the work we do is actually writing it and sending off the information. Right. But the real talent and skill that comes in terms of you as an experienced long-term disability lawyer is the preparation and the gathering of the evidence. So how did you work with his doctors to get that information?
Well, we usually will speak with the doctors, whether it's with the client in the office or just on our own, if the doctors want to. Some doctors don't want to speak with us, and that's fine. And if they don't, I always tell them whatever they do, put it in writing and send it to us, and I review everything the doctors write. And if whatever they put in their letters or their forms is not up to par to support the case, I work with the doctors in correcting all of that. But usually we will have conferences with them and explain to them the importance of the documentation, because doctors don't really know this. They're treating the patient to get them better. Right. They're not treating a patient so that they can get them approved for disability claims. So we teach them how to document and what's important to write in order to get the claims approved, and not only just approved, but to keep them on claim ongoing into the future.
Well, what's so frustrating about this one, and it's a pattern I see at Reliance Standard in particular, because every company's different, is that if Reliance Standard, just from our experience, from us seeing thousands of Reliance Standard denials over the last 20 years, if they get a piece of evidence from their own person that they hired that supports that the person is able to return to work and shouldn't be disabled, they just adopt it.
Yep.
They don't. The person who gets that is basically trying to say, I got it. I got the piece and I can deny them. And then I'll send them a denial. And if they appeal, great. If not, they don't. And it's like, I got it off my desk. I cleared it off the books. Our numbers will look better this year because we'll be paying out less dollars, at least for the next couple months while the person does the appeal. And if I'm wrong, then we'll pay them. Right. And it's really sad because not every company is like that. But Reliance Standard especially, I tend to think, is more ruthless, and often the denial letter was probably minimal at best.
Well, yeah, and there's no, and they know even if they end up in federal court, there's nothing that they have to do other than pay the past benefits they already owed them, and maybe pay attorney's fees. So why not? They behave badly because there's no punishment for their bad behavior. Right, and that's a function of the ERISA regulations, which we try to get a punitive aspect to that. Now, hopefully, somewhat punitive is the fact that they have to pay attorney's fees, and a firm like ours, when we go for an attorney fee award, would command a higher hourly rate, which they have to pay. But at the end of the day, you're talking $1 billion company, and they're going to pay out $50,000 in attorney's fees. Plus, they don't care. They'd rather say, let's knock out these claims, not pay them
few of them will get fought. We'll win some, we'll lose some. At the end of the day, we'll benefit. So it's unfortunate. No one should have a false sense of security that Reliance Standard actually cares about them, because they don't.
No.
I don't say the same about every company, but Reliance Standard just doesn't. So this was a sad case, has a good outcome, the fact that you were able to win.
Yeah.
Surprising in the sense that such horrible injuries, but yet, you know, the takeaway from this, from what I'm hearing from you, is that you can't ever let your guard down.
No.
You always have to document the medical records, and you know, even if you think you're okay, you can't go into the doctor macho. You got to go in and you got to complain. You got not exaggerate, just complain. This is what it is. I have difficulty walking. I use a cane. I'm in pain. I sleep in a chair at night. I have 3 hours a day of pain. I sleep for 2 hours a day. I forget things. I can't focus. I don't want to talk to people. It's not fun. It sucks being in pain. So they have to articulate these things, and you got to tell the doctor, please put this in my medical record, or bring a note and say, doctor, can you put in, here's all my complaints of the last 3 months, put it in. You got to check all these boxes. So congratulations to your client, congratulations to you on winning that appeal. If you're someone who has a Reliance Standard long-term disability claim, no matter what stage you're at, feel free to call Rachel, myself, any of our long-term disability lawyers. No matter where you live in the country, we're available to help you, and we'll immediately provide you with a free phone consultation. Hi, I'm Gregory Dell, the managing attorney of Dell Disability Lawyers, and I hope you find the video you just watched helpful. We put these videos out all of the time, and we'd love if you would subscribe to our YouTube channel. Beyond our videos on our YouTube channel, we also have lots of information available on our website at diattorney.com, and we encourage you to come to our website. The goal is that we want you to be educated about the disability insurance process, and when you get to our website, you'll see that we have information all about your specific disability insurance company, your occupation, and your medical condition. And we've designed our website such that you can easily search our website to find things that you may specifically be looking for. Now, at our website, we have thousands and thousands of pages of information, hundreds of videos that you can search, plus we're building a section of reviews of all the disability insurance companies, and we have the Ask Our Lawyer section where you can go ahead and ask us any questions that you may have. Now, we realize that you may not need us right now, but you may need us in the future to help you with your disability claim, and we think one of the best ways to keep in touch is by clicking the button below and subscribing to our channel. And most importantly, again, no matter where you live in the country, we're always available. Just go ahead and give us a call. We're happy to discuss your claim and let you know immediately if we can help you.